and I'm gonna send out the recording for folks. So yeah, for folks that are here, Carlos is gonna go ahead and do a quick presentation on his organization, and then we're gonna go ahead and get started with the webinar.
Okay, thank you, Anna. Appreciate the invite, and it's great to be here with all of you. My name is Carlos Gutierrez. I'm the Deputy District Director with the Small Business Administration, San Francisco District Office. We are one of 6 district offices throughout the state of California. I represent here, obviously, the San Francisco area, and also the 14 counties in Northern California. We also have offices in San Diego, LA, Orange County, Fresno, and Sacramento. So I didn't want to take up too much time. I just did want to kind of give an overview of where our offices are located, and also kind of what we do. Over the last year or so, 2 years going on here, we've had a number of programs that have come up, lending programs and grant programs. The majority of those have sunsetted already, so they've, the application period is ending. But it is good to keep an eye on the agency website, sba.gov, just in case there's new programs that may arise that you may qualify for. But beyond that, there is one that still exists that has funding available, and it's called the Economic Injury Disaster Loan. It's meant to provide funds to companies, small businesses that were, and nonprofits that were impacted by the COVID-19 pandemic. More information can be found on that on our website, as I mentioned, sba.gov. There, up until this week, we were processing loans that were up to 500,000, and just this week going into places, it's increased up to 2 million. Additionally, if you have already applied for one of these loans, there's an option to apply for an increase. So you may want to look into that if you already have one. Also, an important note that I wanted to highlight is SBA has conventional loan programs that may be worth looking into, namely the 7A and the 504 loan program. The 7A has a couple of other programs that come underneath that, Community Advantage. They all have their own requirements and maximum amounts, the loan amounts. More information can be found on that on our website as well. I've also provided a brochure to Anna and team that they can share out with you that has a lot of good information about the specifics of those two loan programs, what they can be used for. For instance, 504 is mainly for large equipment and land purchases. It gives you their interest rate amounts. Additionally, the brochure lists our technical resource partners that we have throughout the state and gives their websites with a really great web resource. So if you're looking to get some more information about a loan, or develop a business plan, or need help with your financials, or looking at maybe developing a better marketing plan, these are all great resources. They come into in several categories. The Small Business Development Centers is the first one. It's a large network. You'll notice there's about 14 locations listed there. There's also SCORE, which is a great resource for mentorship and advice. They are a core of retired executives. There's also the Women's Business Centers, the Veterans Business Centers, and the Procurement and Technical Assistance Centers. All of these receive funding from SBA, except for the last one, the PTAC, which does receive government funding, and it comes from DLA, which is part of DOD. But because they receive federal funding, most of the services, 99% of those services are going to be free. If they do have anything that there's a charge for, it's usually minimal. It's usually because there's a third party maybe coming in to teach a class or something. Also on the brochure, apologies, but if you're interested in the Veterans Business Outreach Center, that information on the brochure, we need to update that. So feel free to contact me. Anna and team have my contact information. But just for everybody's benefit, I'll say it here real quick. It's carlos.gutierrez@sba.gov. And you feel free to reach out to me if you have any questions. And also if you want the most current Veterans Business Outreach Center information. Additionally, if you have questions related to any of the contracting programs or potentially other loan programs, feel free to contact us. You can certainly send an email directly to me or just send a message to the San Francisco District Office. That's all. I didn't want to take too much time. I'll turn it back over to you, Anna. Thank you very much.
Thank you, Carlos. And thanks everyone. And also sent Carlos's contact information over the chat. And I will send a brochure with information that might be helpful for folks looking for some financial support in the by the way of loans. So yeah, and then we can go ahead and get started with our presentation. And Jake is going to go ahead and get us started with that.
All right, just let me get this pulled up so the right thing is displaying, and then we'll be off and running.
I also wanted to add that if you have any questions during the presentation, Jake does have some places where he pauses and lets folks ask him questions. You can go ahead and submit your questions via the Q&A box, or you can go ahead and send them through the chat.
Okay, are you just seeing the normal slide?
Yes.
Anna? Okay, great. All right, well, thank you all for joining us today. My name is Jake Christensen. I'm an associate attorney at the law firm Aaron Fox here in San Francisco. And today we'll be talking about various commercial lease negotiation tactics for small business owners. The presentation today is part of a partnership between the Lawyers Committee for Civil Rights and Aaron Fox, and is specific to San Francisco. We will not be providing legal advice today, just information. And if you are seeking legal advice, we'll talk about an opportunity to sign up for a commercial lease consultation, which are 1 hour limited scope and free of charge. So it's an opportunity for you to speak to a lawyer and get a bit of legal advice without having to hire an attorney, at least in the interim. And we'll talk about how you can sign up for those at the end of the presentation. For our agenda for the day, we will talk about sort of first steps you want to take before negotiating with your landlord, go into relevant protections in San Francisco, and then go into tips for negotiating with your landlord, and then leave time for questions. And as Anna said, we'll stop after each of these different parts and allow for questions that may be relevant to the preceding section. So before you go in to negotiate with your landlord, or at least open that conversation, it's really important to gather all of your lease documents and at least sort of leaf through them. You want to make sure you have all of the exhibits or appendices. If you have an original lease that you then sublet, or you sublet from someone who had the master lease, you want to make sure you have all the documents that make up the landlord-tenant or landlord-tenant subtenant relationship, so that you know what you're looking at. If you have leased your space for multiple lease terms, sometimes the lease will just include an option to extend, which means you just have to provide written notice to the landlord that you want to exercise the option to renew your lease. Other times they write a new lease, or there's an addendum or something like that. So just make sure you have all those documents before you start. And we do have some folks who don't have a lease. So maybe it's just an oral agreement, or someone just allowed you to operate in this space and you don't have anything in writing. If you have any written communications, emails, texts, paper copies of anything that hints at an agreement, and always helpful in this situation is copies of your canceled checks. So if you pay your rent by check and you can show that you have consistently paid monthly rent to the landlord, that can all be useful as well. So leases are not the easiest thing to read, even for a lawyer. So we don't expect you to be able to take a look at it and know exactly what everything means and fully understand it. That's a great reason to sign up for a commercial lease negotiation consultation. But if you see different phrases or language, it can be helpful to just highlight them or flag them. If you have common area, which are sometimes called CAM fees or other shared expenses, if you see the word abatement anywhere, which usually means reduction or elimination of rent, there's a way that you maybe could get some of your rent reduced during times when your business was required to be shut down pursuant to government orders or different operating restrictions over the last year and a half. There also may be abatement rights if your landlord at any point cut off your utilities, sanitation, janitorial services, or limited your ability to access the space. So keep an eye out for those. If you see the words force majeure, these are, or this is language or a clause that usually means act of God. And so that would be something that would excuse your performance under the lease, meaning that, if something like a government shutdown or a global pandemic, I'm guessing the clauses aren't going to say that specifically. But if they give any out to not paying rent, oftentimes you'll see force majeure, and it will say at the end, any of these occurrences does not excuse the payment of rent. That may be the case, but we have seen some where it did at least limit the landlord's ability to charge rent during the applicable periods. If you see anything about frustration of purpose or inability to use the space for the contracted purpose, which if you have a lease, it's likely to operate a business, that could also be useful. And anything talking about your right to access or use the premises. So if the landlord, there was one tenant where the landlord was doing construction or renovating the space during the height of the pandemic, and the tenant tried to go into the space and couldn't access it, but had not given any permission, had not been asked if the landlord could go in and do that. So keep all those things in mind. You may see something called a condemnation or casualty provision, usually in San Francisco in particular, but California generally, and a lot of times on the West Coast. There are provisions related to an earthquake and an ensuing fire, or if the government has come in and is going to put in a freeway or something. So keep in mind if you see any sort of carve outs for loss of access or use due to governmental action, that would not be in the traditional earthquake or government coming in and taking over the space to put up some sort of public building or construction. If you're in a building with multiple spaces, maybe you rent a stall, sometimes the leases will require that the landlord maintain a certain level of occupancy. And obviously during COVID, many of these commercial spaces were empty. So that could be a way to reduce some of the rent that you owe. And sometimes if there's failure to maintain occupancy or operation requirements, then it can give you a right to terminate or grant you other rights that could be in your favor. Other language you want to keep an eye out for: quiet enjoyment rights. You want to also flag provisions dealing with your security deposit. And we'll talk a little bit about this, but there may be language saying that if you apply your security deposit toward unpaid rent, it has to be paid back by a certain time. Any language like that, you'll want to note that. And a good reason to sign up for one of the free consultations is that the assigned volunteer attorney can talk about maybe other opportunities or other grounds for reducing or getting forgiveness for some of your unpaid rent. Throughout this process, while you're gathering your lease documents and reviewing them and starting to initiate conversations with your landlord about figuring out repayment or getting more time, it's just important to keep an open dialogue. So with the moratorium, which at this point appears to be ending at the end of the month, if you haven't made that communication for September that you're economically impacted by the pandemic and are only able to pay partial or no rent, it's important to do that even for this final month. But you want to at least do the minimum, even if the landlord's not responding. And keep copies of all written and other correspondence. So if you send any letters to your landlord, any emails, text messages, voicemails, you can't make a copy of that, but you can save it in your notes app on your phone. You can email it to yourself. Sometimes you can create a subfolder in your email account, and you can just drop the emails that you've sent to your landlord and received from him or her there. You can scan and email yourself copies of hard copy notices, and then that way you have everything in one location. It's good to just keep everything organized in case you ever need it down the road. And if you have a business interruption insurance policy, it can also be good to pull that and save it for your lease consultation so that the volunteer attorney can take a look. And with that, I will go ahead and pause for questions.
I think it looks like we have a couple questions in the chat.
So I see that here. All right, so let me take a look at these. It looks like there's a question for Carlos, which I'm guessing you can pass on to him unless he's still here in the chat with us. And so we have a question about tips or advice to approach landlords about asking them to forgive back rent owed. And we'll talk about that in the third part of the presentation, so that's coming up. And for frustration of purpose, that can be independent of language in the lease. So it's helpful if the lease does specify what the contract is for, which usually is to operate a business in a commercial space. So it'll say, oh, this is only to be used for a coffee shop or for a restaurant or for to sell clothes. And so that adds to the argument that the purpose of the contract was frustrated by the government action forcing you to not operate. But that argument can be made independent of any language in the lease to that effect. All right, that looks like it's it for questions, unless you see any elsewhere.
That's all I'm seeing too. Thank you, Jake.
Okay. All right, so we'll move on to, and it looks like we do a question. You can go ahead and work on putting that in the chat box, and then I can come back to it after this next section when we take our next break. It won't take very long. So San Francisco's current eviction moratorium extends through September 30th, so end of this month. In the past, they have extended it pretty close to the deadline. Governor Newsom last extended it early in the summer, so there may be another extension, but it's always good to prepare as if there won't be one and hope that there will be some additional relief. Qualified businesses are those that have been financially impacted by the COVID-19 crisis and missed rent between March 17th, 2020, which is when the shutdowns first began, and through the end of this month or whenever the moratorium ends, if it's extended. You have to be registered to do business in San Francisco and have gross receipts at or below 25 million. This is previously based on your receipts in 2019. But I'm guessing for 2020, very few businesses that would qualify here have gross receipts anywhere close to that 25 million cap, so most businesses should qualify. The protections extend to various types of tenants. So traditional folks who have a lease for a set term. It applies to subtenants, so where you've leased from someone who previously leased the space, and also month-to-month or holdover tenants. So if your lease ended and you went onto a month-to-month lease, normally the landlord or the tenant have the right to give 30 days notice to terminate. And under the moratorium, the landlord would be prohibited from terminating a month-to-month lease. You would still have the option as a tenant. And then a holdover tenant is a situation where the lease has ended, the landlord has not agreed to a month-to-month arrangement, and you've remained in the space anyway. And so technically holdover tenants, a lot of leases will have a provision where if you're not able to reach an agreement and you remain in the space after the last day of the preceding lease term, you're a holdover tenant, and then it will specify what rent you pay, which is usually a bit higher, and all of that. But anyone who's occupying a commercial space tends to be included in the protections. And it's also important to note that rent is not just the monthly rent. It includes any sort of additional rent or CAM fees that you might see in a lease, security deposits, repaying those if they're applied to rent, late fees, and interest. So landlord can't charge you late fees or interest for any rent missed during the moratorium period, which we'll talk about in a bit. And they also can't require you to pay additional rent or replenish the security deposit in addition to your monthly rent during the period. The trick is if there's any outstanding rent owed once the moratorium ends or outside of any forbearance period, then the landlord can start charging interest fees and late fees and interest on missed rent after the moratorium ends. And so to claim protection under the moratorium, you would provide written documentation to your landlord that the coronavirus outbreak has had a financial impact on your business. I'm guessing most of you have already been doing this if you've exercised your rights under those protections. But if you haven't, given that September is the last month and we're still close to the beginning of the month, it would be good to formalize it. So we've talked to some tenants where they've just been in touch with the landlord and they've said, business is still struggling. I could pay you half rent. It's been more informal. If you haven't ever provided written notice of inability to pay rent, even if the landlord has worked with you, it can be good, particularly since we're at the last month currently of the moratorium, to just send a written notice or even a text message so that it's documented saying, as has occurred in previous months, and even, since March 17, 2020, we've been impacted by the pandemic. We are only able to pay X amount this month, or still unable to pay full rent. And it gives you another 30 days to try to repay the unpaid rent, which at this point would protect you through the end of the month. But again, keep discussing payment terms with your landlord. We'll talk about how to go about that in the next section. And in the case that the moratorium is extended, it's just important that you do this each month to continue to qualify for protection, because you provide the written notice, gives you another 30 days, only as long as the moratorium is in place, but you've got to keep updating that. And it's important, as I referenced a short time ago, so you're not required to pay any rent or anything that is qualified as rent under your lease during the moratorium. But again, important to pay what you can so that there's not a huge amount of unpaid rent sitting there once the moratorium ends, whenever that may be. And it's also important to note that the landlord can agree to additional extensions that go beyond the moratorium period. So if the moratorium ends at the end of September, you and your landlord can come up with a more generous arrangement that gives you more time to pay things back or knocks off some of the unpaid rents or things like that. It's really up to the landlord, however. And it's also important to know that the moratorium does not include rent relief. It just gives you more time to pay it back. So everything that you have not paid is still owed unless the landlord gives you some sort of break on the unpaid rent. The moratorium also does prohibit the landlord from modifying leases that were in effect as of March 17th, 2020. So if the landlord is trying to add additional terms to your lease, or say, you have to sign this addendum, and saying that you're going to pay this much more rent or whatever, unless it's a new lease that you're entering into, the landlord is not able to do that. And so the point of the protection of the moratorium is that the landlord can't evict you without providing written notice. They have to give you 30 days to pay back the missed rent. And this is why you continue to do the monthly written notice to the landlord that you continue to struggle because of the pandemic and are not able to pay full rent or rent at all. And for this reason, the landlord's not able to evict you as long as you are keeping up with those monthly notices. So it's important that you at least do that minimum step of providing written notice and keep trying to work with the landlord to reach some sort of repayment plan. If you haven't paid all outstanding rent after the repayment period that you agree to with your landlord or after the moratorium ends, then the landlord could move forward with proceedings to evict you for non-payment of rent, which in California is called an unlawful detainer action. And those have all been on hold, at least for non-payment of rent in California during the moratorium. So we're not sure exactly how those will all be dealt with, because I'm sure there will be a lot if and when the moratorium ends. But typically before COVID, there was a lot of encouragement by the courts for the parties to try to reach an agreement. And so even if the moratorium ends, and particularly given the increased volume, I think it's probably likely that courts are going to encourage informal mediation or settlement to try to come to some form of agreement to end the eviction proceedings and at least give you a shot to try to repay things. And if you miss a payment again, or if you and the landlord reach an impasse, then it would maybe be time to go back to court, and then the court would weigh in on the situation. And that's only to say that even if your landlord files an unlawful detainer action, doesn't mean you're going to be kicked out tomorrow. It doesn't mean that it's going to go quickly, or that the outcome is certain. There's still opportunities to try to negotiate even at that point. San Francisco in particular has sort of a unique ordinance that was passed by the Board of Supervisors in December. And that ordinance created 4 tiers of tenants based on the number of employees. And so tier 1 businesses that have 10 or fewer full-time equivalent employees have 2 years to repay deferred rent from the date that it was due. And so it just gives more time for those businesses to repay that missed rent. And unique to the smaller businesses, there is an option to terminate by giving the landlord 30 days notice. So even if your lease still has a couple years left, or even a couple months, if you and the landlord aren't able to reach an agreement that doesn't either comply with the board's ordinance or something that's more generous, so maybe gives you 3 years to repay, say the landlord will only agree to 1.5 years for you to repay your rent, that would be grounds for you to provide written notice of termination. You do have to pay all rent that is due through the termination date. So if you say that you are going to terminate within 30 days and provide that written notice, then you would need to pay rent through that time. But there would not be any way for the landlord to charge you extra fees for terminating early, late fees, or interest, because that rent was all due during the moratorium period. For larger businesses, you have decreasing amounts of time to repay the rent based on this number of employees. So the bigger the business, the less time. And for tier 4 businesses that have 50 or more full-time equivalent employees, they have to pay all deferred rent by the time the moratorium expires by the end of September, up to 12 months if you have between 25 and 49 employees, and up to 18 months if you are between 10 and 24 employees, full-time equivalent employees. And so as we've said, landlords can't assess interest or late fees for rent that was due. or penalties or fees in connection with an early termination. Landlords and tenants can negotiate or enter into agreements on terms that are better than those provided by the ordinance. But if you can't agree to terms that are at least as good as the ordinance or better, then you can exercise, at least as a tier 1 tenant, that option to terminate early. And we'll have some more time for questions here. I know that there was one that came in that I will take a look at now, but if others have them, go ahead and enter them in the chat box. All right, so the first question, so if a tenant has a lease that is expired during the moratorium, is the landlord allowed to charge 1.5 times the rent in the lease for the holdover? I would encourage you to go ahead and sign up for a lease consultation just to be able to take a close look and get all the facts and review the language. But typically, if your lease expires and you don't have an option to renew, or you're not able to agree to a new lease and new terms, if you remain as a holdover tenant and the lease as it existed on March 17, 2020, landlord not changing anything or adding anything, said that the landlord could then charge 1.5 times the rent under the lease, that would most likely be permissible. But again, this not being legal advice and wanting to have someone really take a look at it, you should sign up for consultation. But if it's in the lease and otherwise would be allowed, it most likely would be permitted in this case, the moratorium notwithstanding. Someone also asked when the option to terminate clause expires. To my knowledge, the option to terminate can be exercised anytime up until September 30th. So as long as you provide the 38 days notice by the end of the month, that would be covered. And you also want to keep in mind that the moratorium may not be extended. And so if you put things up until the last minute, you just don't want to be in a position where you aren't able to get the written notice out or make sure that the landlord receives it in time. So if you're thinking about using that option, you want to assume that the moratorium is not going to be extended, even though it may be, just so that you're able to exercise that right if you end up needing to. There's a question about just the general trend of businesses going partially or fully remote, and many of those businesses having ongoing leases, and talking about some sort of program that would basically give them an out or some sort of forgiveness for cutting back on emissions from having employees who aren't commuting and things like that. I'm not sure of anything like that, and I don't really know of any context. I think that would maybe be a good question for a supervisor or someone at City Hall. I think that would be more of a policy or a potential legislation question, similar to some of the moratorium provisions and some of the proposed rent forgiveness and different things like that. I think that would tie in. So I'd recommend reaching out to your supervisor for your district with that sort of question. That would be less of a legal question. Another question about having to be shut down because of city and county orders and being unable to afford rent during that time. But it sounds like the landlord didn't allow them to, or didn't agree to renew the lease, but then is charging them more money as a holdover tenant or something. I think that one is going to be one for a lease consultation just to make sure that we understand all the facts. Because it sounds like a similar holdover situation where I think maybe there was an option to redo the lease, but it was not. The landlord didn't allow you to exercise it because of previous non-payment of rent. So I would really suggest a consultation just to make sure that whoever the volunteer attorney is can get all the facts in the background, and then also review the provisions to see if there's any way around that or way to push back on the landlord. And I think that does it for questions at this point, so keep them coming. Thank you very much for putting those in. We'll move on to the negotiation part of the presentation, and if we have more questions that come along, happy to answer those. So moving on to the final part of the presentation, negotiating with your landlord. You've looked at your lease, you understand the current protections in San Francisco, which again may be extended. And so how do you go in to this process? And really the key thing to think about, and this it applies whether you're a landlord or whether you're a tenant, is getting the other side to come to the table and negotiate, and thinking about where both sides are at. If you're a tenant, obviously, in almost all cases, you've been a great tenant for months or years. You've paid your rent on time. You have improved the space that you're operating in. The only variable has been this global pandemic that no one could control and prevented you from operating your business. That's the only thing that has kept you from being able to pay rent on time and in full. And so your goal as a tenant is to continue to operate your business, to agree to reasonable repayment terms that allow you to make a living and keep operating your business while also trying to take care of as much of the back rent obligation as you can. If you're a landlord, you most likely want to be paid as much as possible of the unpaid rent. And there's a way to try to find a middle ground there that meets both sides' goals. And it's really important to think about what both sides are looking for coming into a negotiation, so that you're not making one-sided offers or not thinking about where the other side is coming from. It can really help you gain a lot of ground in this process if you just sort of kind of work that empathy in. And I know it can be acrimonious at times, and many landlords rely on the income from rent to pay their bills, and much like tenants rely on their business to be able to pay theirs. And so it just becomes a sort of a snowball effect. But if you keep open lines of communication and continue to talk to each other, usually you can find some sort of workable arrangement. And so it's important to make a realistic ask. And when I say realistic, it means looking hard at your numbers, looking at the way that the business is trending. Things have been reopened for the most part for a couple months now in San Francisco. Is traffic picking up? Are your weekly revenues going up? Are you getting more new customers? If you're able to track that, it just sort of shows you kind of where things are going, because you don't want to have sort of stagnant or decreasing revenue and then agree to pay your landlord full rent starting in October plus another full month's rent each month to repay the back rent when you already been bringing in that much in revenue. And so it's about going in with a number that you can feasibly pay regularly, because another thing you don't want to do is say, oh yes, I can pay X amount, and then after a month or two you realize that you sort of oversold it a bit, and you're getting behind and you're not being able to pay that, or maybe you're not paying other bills so that you can keep up this commitment you made to your landlord. You want to avoid that as much as you can, and it's just going to make things better for you and for the landlord to not have to keep renegotiating this every couple months. And so while you want to make a realistic ask, in all negotiations, keeping in mind what the other side is looking for, it never hurts to start with sort of your best case scenario, and then you'll kind of work to find a middle ground. If you start out already having given a little bit of ground, you're going to end up more on the other side's, the other party's side of the line a bit more than you'd like to, rather than meeting in the middle. So it's good to at least start there and then kind of work your way into a middle ground. And so something You know, like your best case scenario could be abatement of unpaid rent during the times your business was shut down during the pandemic, getting more time to pay the rent back beyond September 30th, or get rent reductions on top of the abated rent when you were open in a limited capacity. You can kind of tailor it to your individual situations. And I guess going along with deferrals, so you could maybe get more time to start repaying the rent and then also get more time to repay it once you start repaying. So a little slight difference there. You could either through the landlord or separately convert the back rent into a loan, which we'll talk about some of the current funding opportunities available, but either take out a line of credit or, you know, ask the landlord, can we just move this unpaid rent into this separate tranche, and, you know, I'll pay you X amount per month, you know, with interest, and you know, pay it back this way, and that way you start, you know, paying rent on a forward going basis with a clean slate. You could ask that the landlord credit your deposit that's on file toward your back rent. A lot of these commercial leases, the monthly rent is pretty significant, and sometimes you put a month or 2 months of deposit down, and that could be a way to quickly chip away at a big chunk of your unpaid rent, and then give you more time to repay it if the lease says that you have to repay it within 7 days or a month after it's been drawn on to cover missed rent. That could help a little bit. You can ask for forgiveness of back rent that's owed, which kind of goes to the abatement. And sometimes we've seen tenants that have, you know, said, well, if you forgive, and this was earlier in the pandemic, but if you forgive, you know, the prior months, then I'll pay full rent moving forward, rather than, you know, having to ask for a discount on future rent to repay back rent. If your lease term is about to end, you could say, you know, I'll agree to an extension or a renewal if you forgive, you know, X amount of the back rent, and we can just start things over on a new, you know, turn on a new leaf. You could also ask if the landlord has received any kind of assistance during the pandemic, and that may make him or her more willing to give you a break if they've gotten a break either from their lender, or they've, you know, qualified for certain assistance to help them kind of weather the pandemic. That way it's not all being pushed down to you. And so along with, you know, making that realistic ask, you also want to make sure that you're not overcommitting. Some tenants have successfully negotiated to repay unpaid rent based on a percentage of their monthly revenue. And an advantage of this versus, you know, agreeing to pay a set amount every month is you're never promising to pay more than you bring in. If you say, well, okay, I'll put 10% of my monthly revenue toward repaying back rent. If you bring in $10, $1 a month will go toward that. If you bring in more money than you were before the pandemic, then the landlord has a chance of actually earning or getting repaid more quickly than he or she would if you promise a set amount if your business is doing well or continues to grow. So it has sort of a dual benefit. Some landlords will balk at it because they'll say it will be less money than I would get if you know, promise to pay a certain amount, but that can in the long run end up being more if your business is doing well. And that is the same for converting base rent to a percentage rent, either temporarily or for a longer period. And that way the landlord's always guaranteed to get something. You're not overcommitting, not knowing what your revenues are going to be like if things are a little shaky and haven't returned to normal yet. And it just sort of, it opens the possibility that, again, even with the base rent, the landlord could end up getting more in rent through a percentage rent than they would under a set monthly rent if your business does really well. And at the same time, you know, don't feel like you have to try. If you have reached out and made good faith attempts to try to negotiate with your landlord, you know, or if you, the landlord, have tried to reach out to the tenant to try to come to some form of agreement, you know, neither of you needs to endure any sort of threats or verbal abuse or just anything beyond just general rudeness is not ideal given all the other stressors and things that people are dealing with. So, you know, do the minimum communication necessary to preserve your rights under the moratorium. You know, try to initiate negotiations, but if you feel that it'll be futile or it's not going to work, you don't have to keep beating a dead horse either. And it's important to know that the moratorium protects tenants regardless of what landlords try to do. We've seen landlords that have tried to sidestep moratorium protections by claiming that tenants have breached the contract, even though the underlying claim is really based on non-payment of rent, which is not allowed under the moratorium. And so you just want to keep in mind that there are things there. And similarly, we've had landlords that have said, in response to a tier 1 tenant trying to exercise the termination right, that the tenant owed late fees and interest fees for months of rent missed during the pandemic, which, as we've already said, is not allowed under the moratorium either. So that's when it can be really a good time to sign up for consultation, just to kind of go through some of those and have some issue spotting and just make sure that everything is kosher. In terms of what comes next, as we've said, it's not clear whether we'll see further extensions of Governor Newsom's executive order that allowed cities like San Francisco to extend their moratoria through the end of September. That was a 3-month extension the last time, so we could see one through the end of the year. It could be for another month. It really just depends. So stay tuned for that. It probably will be decided toward the end of the month. In terms of defenses to non-payment of rent, which relate back to some of the provisions in your lease that we were talking about, that may give you a little bit of leeway to go back to the landlord and say, okay, yes, I missed these months rent, but based on the lease, during these months that we were required to be shut down, I'm entitled to abatement if that language is in the lease, or you can make a frustration of purpose argument. The purpose of this lease was for me to operate my business in this space, and that purpose was frustrated by these government shutdowns. And so kind of use that to try to negotiate down some of the rent or get some of it forgiven. But if it goes to an actual unlawful detainer proceeding, we're not quite sure how those sort of defenses are going to shake out. I think that will just depend on when courts start hearing them and entertaining those, but it's good to sort of get those lined up now through a review of the lease in case it gets to that point. And just as you're trying to decide what to do, if you're thinking about exercising the early termination, if you're a tier 1 business, just keep in mind that the end of the month will get here sooner than you think. So if you're looking into alternative funding options, which we'll show some of those in terms of applying for a loan to convert the back rent and get that brought current before the moratorium ends, reach an agreement with your landlord. You want to start that process now so that you're not reaching out for the first time on September 30th, trying to find a way to keep your business going. And at the same time, while you pursue those negotiations, keep looking into available funding resources. They have gone down as things have started to reopen, but there's always a chance that more funding could be made available, particularly at the federal level if more relief is issued. And there may be new opportunities as budget years change over, even at the state level or the city level, if more money is allocated to help businesses kind of get back on their feet and back to normal. And the website for that is listed here, which if you just search SFOEWD, there is a big red banner at the top of the page that says COVID-19 resources for businesses, and it will take you right to the financial resources that are currently available. This is the screenshot of the ones that were available as of this morning, and includes 0% interest loans up to $100,000 for the SF Small Business Recovery Loan Fund. Similar loans with a small interest rate are available through the CA Rebuilding Fund, and the EIDL loan, which our colleague from the SBA mentioned. Those loans can be for up to $2 million and potentially have the opportunity to get additional funding. They're also low interest, and repayment on this one and on this SF Small Business Recovery Loan, the first payment is deferred for a year. So on top of the low interest and a longer repayment period, they give you more time to start repaying it. And they all have different requirements, but these first two are in pre-qualification, so you can go on, see if you qualify and get an application entered so that it's pending, and you can apply for the EIDL loan today. So if you're interested in signing up for a commercial lease consultation, you can of course, visit the Lawyers Committee website, which is lccrsf.org, for additional resources. If you want to sign up for a virtual consultation, or if you think you might need longer term negotiation assistance, you can go to this tinyurl.com/LSE application link, and it'll present a form that you can then fill out, and then you'll be screened and placed with a volunteer attorney for a consultation. That does it for our presentation. So if I don't see any additional questions in the chat box, if you have any that have come up based on the last section, we'll hang around for a few minutes here in case you have any.
Okay, there is one in the Q&A box. Are you able to see that one?
Oh, yep, I do see it. Sorry, there's a chat box and a Q&A box, so let's get confused. This is a good question. Okay, so the moratorium requires that tenants present documentation to the landlord showing that they have been financially impacted. And that documentation does not have to be your profit and loss statements. It doesn't have to be accounting records. It doesn't have to be tax records. Sometimes landlords will demand to see them, and they'll say, oh, I want to see this, 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 and this, and basically want to do an audit of your financial records. Not required to produce all that. Our understanding during the pandemic has been you just need to basically in writing state that you are economically impacted. It has to be objectively verifiable. So if it were to be challenged, you would basically need to be able to back it up. But in that initial communication to the landlord, you don't have to provide documentation showing, how the business has done financially. You just have to provide a written communication. And so it's really, your business, what things are like when, prior to the pandemic, how they've been now. And so if you, objectively looking at it based on your ability to pay rent and your other bills and those sorts of things, objectively feel that your business has been financially impacted, then you can just say that in the written communication, text, email, hard copy letter, and that's enough. But, you do just want to make sure that it's a legitimate claim. And you wouldn't want to not be financially impacted and, be doing well or better than you were before the pandemic, and then, try to tell the landlord that you're unable to pay rent when you could. So it just has to be a good faith evaluation of your financial impact because of the pandemic.
That looks like all the questions straight to me.
Oh, and I do see, I think there. Oh, yep, I see you answered the one for landlords whose tenants haven't been able to pay rent. And so it sounds like LCCR is going to be providing some more resources there. But I think when it comes to landlords, a lot of that may be starting either if you can't reach an agreement with the tenant from the landlord perspective, then that's where the unlawful detainer actions will come in. And sometimes that may also prompt a tenant who's been non-responsive to come to the table. And so, by filing that initial action, assuming that the moratorium isn't extended, that can at least, prompt a response and make them, understand that you're serious. Sometimes in that case, tenants will then vacate voluntarily. Sometimes they will pay you, a chunk of money right there to get you to hold on the unlawful detainer. It really just depends. But, worst case, you would pursue the unlawful detainer action, go through the process to get the tenant removed, and then go about collecting the unpaid rent after the fact. All right, well, that looks like that is it for our questions. Thank you all for coming today. If you have follow-ups, you can reach back out to the Lawyers Committee, and they can always refer your questions to me. And the pro bono legal assistance is through the lawyers committee, and that's that online form that you'll fill out to be connected with a volunteer attorney for consultation. All right, thank you all for joining. You have a great day.
Thank you, everyone. We'll go ahead and send out the presentation as well as the recording of the webinar and some other resources as well in our email. And thank you so much for coming. Thank you, Jake.